I am Jerry Korngold, Dean of the Law School, and it is my pleasure to welcome all of you here today to Case Western Reserve University School of Law. I am welcoming not only people sitting in this room here with me, but to those of you who are watching upstairs as well. We also will have people involved in watching this program as well by webcast. And we are really thrilled to have all of you here and recognizing the value of having such a distinguished guest visit our law school and giving us the opportunity to talk about important and timely issues with him and with our colleagues here today. Like many recent lectures at the law school, today's program is presented by one of our academic centers of excellence, which collectively have been addressing the latest issues affecting our country and the world, even as they unfold. The Institute for Global Security Law and Policy was established last year to specifically address global security and counterterrorism concerns in the post-9/11 world. The center's unique, multifaceted, and multidisciplinary approach encourages students to blend theory and practical applications in their study of counterterrorism and international law by giving our students the opportunity to provide research assistance to agencies and individuals tackling this problem on a day-to-day basis. I recently received a letter from Colonel Morris Davis, our distinguished speaker today, thanking the law school for the work our students have done through the Counterterrorism Lab to assist the Office of Military Commissions. The Colonel wrote, quote, "The students' efforts are a tremendous help in this historic effort to bring unlawful enemy combatants to trial before military commissions, a significant step in the global war on terrorism." Our Counterterrorism Lab is taught by Professor Amos Giora, who also directs this institute. Professor Giora happily joined us last year after serving 19 years in the Israeli Defense Forces, retiring at the rank of Lieutenant Colonel. Professor Giora and Assistant Director Professor Jesse Hill have also positioned the Institute as an invaluable resource to government, business organizations, the legal profession, and the general community on the critical issues of security and counterterrorism. I encourage you to visit the Institute's website and blog to find up-to-date coverage and discussion on these topics. But right now, I'd like to especially thank our distinguished speaker for coming to talk to us about these issues, and to also especially thank Professor Amos Giora for providing us with this important forum and the other activities of the Institute. Let me now turn it over to Professor Giora, who will introduce Colonel Davis in today's program.
I'm not as tall as the Dean. Thank you, Dean Korngold. I first met Colonel Davis 4 years ago when, as commander of the Israel Defense Forces School of Military Law, I visited Colonel Davis and his staff at the U.S. Air Force's Judge Advocate General School. Little did I think then that 4 years later, in my capacity as director of the Case Law School's Institute for Global Security, I would have the privilege and pleasure to host Colonel Davis in his capacity today as Chief Prosecutor of the Office of Military Commissions of the Department of Defense. In the fall of 2004, the Department of Defense selected Case Law School to be the only law school in the United States to work with the prosecutors in Guantanamo on a broad range of international, criminal, and constitutional law issues. The legal work that we do here at Case Law School for the Office of the Prosecutor is an extraordinary honor for the students, one that the students, frankly, take very, very seriously. The students are deeply appreciative for the opportunity to impact the public debate. And as Dean Korngold has mentioned, Colonel Davis has expressly written and stated to him exactly how significant the impact is of the students' work in terms of impacting the work of the Department of Defense. It is frankly an extraordinary privilege for Case Law School to be the very first law school at which Colonel Davis will speak, addressing the critical issues of Guantanamo. Colonel Davis was appointed Chief Prosecutor for the Office of Military Commissions in September 2005. He leads a team of legal professionals selected from all the military services and of the Department of Justice. Colonel Davis is responsible for the prosecution of individuals detained at Guantanamo, who the President determines are subject to the Presidential Military Order of November 2001. Colonel Davis has been an Air Force judge advocate for more than 22 years. He served as a staff judge advocate 4 times, including a tour in Saudi Arabia in support of Operation Desert Storm. He was the Director of Legal Information Services, the Department of Defense's executive agent for the development and support of legal information technology, and served 2 tours at the Air Force Judge Advocate General School. He has served as defense counsel, circuit prosecutor, and appellate counsel, where he was responsible for Air Force criminal cases filed with the United States Supreme Court. Colonel Davis has published on enhancing military relations with the press and in government contract law matters. Today, we at Case Law School are indeed honored to host Colonel Davis. Our format will be as follows. Colonel Davis will speak. Afterwards, we will entertain questions from the audience, to which Colonel Davis will respond. Afterwards, there will also be an opportunity to ask further questions at a reception. It is indeed, frankly, my privilege and pleasure to ask you to join me very warmly in welcoming Colonel Morris Davis. Excellent.
Well, thank you. It really is a pleasure to be here. You know, folks ask me, why are you going to Cleveland? I've never been to Cleveland before. Although, to be honest with you, I'm a huge Drew Carey fan, and Drew always said Cleveland rocks. So I can mark this off my list of places I haven't visited. But I always heard about the weather, that it's cold in Cleveland, it'd be waist-deep in snow, but it seems like paradise outside. So I don't know what all the complaining's about. But it truly is a pleasure to be with you. The main reason I told folks that I'm coming to Cleveland is to say thank you to Case Western Reserve Law School for the important work that you're doing. As Professor Gior said, you guys are the only school supporting the Office of the Chief Prosecutor at the military commissions, and we're very grateful for the work that you're doing. I've been there for about 5 months now, and I can tell you I had never heard of the 2-cocaine defense until it was raised in a defense motion not long after I arrived. And I was pleased to find that one of your students here had already written a fairly substantial volume of work on the 2-cocaine defense. So it made our job pretty easy to pull her work off the shelf and craft our response to that novel motion. I tell you, I think what you really want me to talk about is folks that are being forced away from their family, about being malnourished, about sleep deprivation, about folks in a position of authority forcing you to sit down with pencil in hand and spill out everything you know on a piece of paper. But I'm not here to talk about the bar exam. I'm here to talk about the folks that we're holding at Guantanamo Bay and our efforts to bring them and hold them accountable in our part of the global war on terror. People ask, why we're doing this. I can tell you there are people like Boeing employees, Chandler Keller, Deng Chul Lee, and Ruben Ornedo, who were murdered when Al-Qaeda hijacked American Airlines Flight 77 and crashed it into the Pentagon, killing 64 people on the plane and 125 people in the Pentagon. If you look around outside, folks don't realize, or there's not apparent that we're at war, but we are. I can tell you last week when we were at Guantanamo Bay, we had a preliminary hearing on the al-Balul case. You can go out to the website, and I'd encourage you to do so, and in a bit I'll show you the link to get there. But Mr. al-Balul, during the proceeding, said, I don't want this American military lawyer to represent me. I am from Al-Qaeda. He is from America. He is my enemy, and we are at war. Mr. al-Balul has been removed from the battlefield for quite some time, but he understands that we are at war with Al-Qaeda. We get comfortable in our everyday lives, and we lose sight of the fact that we are a nation at war. And folks ask me, are you concerned about your safety? Because I had an article last week that appeared that was Mo Davis, Chief Prosecutor and War Criminal. But I can tell you there are tens of thousands of young men and young women around the world who truly are in harm's way. So any risk that we face in prosecuting these folks pales in comparison to the young men and young women that are doing their job all around the world. So I want to talk just a bit, and again, I'd like to keep this informal, and I'm here to try to answer any questions that you have. There's nothing that's off limits. I can tell you there may be some things that I just can't answer. And I noticed I keep moving. I like to see the camera guy have to work for a living, so and a moving target's harder to hit. So, but no questions off limits. Please feel free to ask questions. I've got a few remarks I want to go through, and the rest of the time is yours. I want to talk a little bit about the enemy that we face. I'll be honest with you, my level of knowledge about the war on terror and Al-Qaeda and about military commissions was probably about the same as any other member of the general public up until August of this year, when I got a telephone call asking if I'd be interested in coming for an interview for the job that I'm in. My family had just moved. As Amos mentioned, we met in Montgomery, Alabama, of all places. But I'd been in Montgomery, Alabama until January of last year, of 2005. I'd moved recently to Cheyenne, Wyoming, where I was the staff judge advocate for 20th Air Force. That's the command that controls all the intercontinental ballistic missiles that are in Wyoming, North Dakota, and Montana. I'd only been there for about 6 months when I got a call asking me to come for the interview, if I'd come for the interview, and I did. I can tell you for my family it was inconvenient to move 3 times in less than 12 months. But as an attorney, this is a historic opportunity that doesn't come along every day. Back in 2001, when this first started, I volunteered to be on the defense side. And I did that for a couple of reasons. One is I thought it would be tremendously unpopular to represent terrorists. 4 years later, I'm finding I may have been wrong on that count, but at the time it seemed like it was going to be extremely unpopular to stand up and represent someone accused of engaging in terrorism. The other thing was that I believe it's critically important that we show the world. Al-Qaeda attacked us, our way of life, and our system. And I think it's critically important that we show the world that our system, no matter how reprehensible the acts are committed against us, that we'll still stand up and extend American rights and privileges and protections to those that attacked us. And I still believe that. So when I was called and asked if I was interested in this job, I took it because I still believe it's important that we show the world that we can provide a full, fair, and open trial to the members of Al-Qaeda. On the pictures that just went by, you saw Osama bin Laden and Al-Qaeda. In 1996, Osama bin Laden declared war on America when he issued a fatwa. In 1998, he expanded the fatwa to include saying it was a duty of all good Muslims to attack Americans, whether they're military or civilian, wherever they're located. That year we had the embassy attacks in Tanzania and Kenya. 2 years later we had the attacks on the USS Cole. And then in 2001 was kind of the slap across the face when Al-Qaeda struck here in America. And it continues throughout. If you watch the news, Al-Qaeda is still using terror as a weapon to try to force the world to adopt to its strict brand of ideology. People have asked the question about, one of the big questions is POW status. Why Al-Qaeda? Why we're not treating these people as prisoners of war? The Geneva Conventions prescribe 4 standards, 4 rules that have to be met for a combatant to be a lawful combatant and entitled to prisoner of war status. That is a clear chain of command, a distinctive uniform that separates the combatants from the civilian population, carrying arms openly, and adherence to the Geneva Conventions. Al-Qaeda doesn't comply with any of those requirements. Therefore, I believe the President was correct when he said that they were unlawful enemy combatants that aren't entitled to Geneva Convention protections. So Al-Qaeda is the enemy that we face, and terrorism is the weapon that they choose. So what do we do with those folks? I have a number of folks that have said, hey, these military commissions, even though we've never done one, we know they're bad. They won't work. They can't produce a fair trial. The analogy that I've used a number of times is, when I was a little kid, I knew something about carrots, and I knew something about cakes. And I knew that carrot and cakes did not belong in the same sentence because it could not possibly be good. This is a true story. So I was probably 13 or 14 13 or 14 years old before I ever tried carrot cake, because I was firmly convinced that a good cake could not contain carrots. So I was surprised when I actually tried it and found that my assumptions were wrong. I believe that to be true with military commissions as well. People say they cannot possibly be fair. We've never done one. I think after we've done one, you can either say they're fair or unfair, but whatever you say, you'll have facts that you can base your opinion on. Again, it goes back to 1969, and I think Amos and I may be the only ones in here old enough to remember this, but in 1969, Joe Namath said that the Jets were going to win the Super Bowl. Now, those of you that are old enough to remember that, the pregame, all the experts that were on, it wasn't a question whether the Jets would win or lose. It was a question of how bad would the Colts beat them. I mean, whether they would win just wasn't an option. It was just a question of how bad they would be beaten. The point spread going into the game was the Jets were a 21-point underdog. The Jets won, I believe it was 14-8 or 14-6 was the final score. When it was over, 16-7, there we go. They beat the spread handily. But when it was over, the post-game analysis proved to be much more insightful than the pre-game predictions. And that's what we've had in the case of military commissions, or a lot of pre-game predictions on how it's going to turn out. Now, I don't claim to be Joe Namath, but the military commissions are going to be full, fair, and open and produce a fair trial for the folks we're holding at Guantanamo Bay. When folks look at the military commissions and they criticize it, they look at, I think, what is an apple and orange comparison. I think Senator Lindsey Graham from South Carolina, when he sponsored the Detainee Treatment Act that was recently enacted, the President signed it on December 30th. Senator Graham is a colonel in the Air Force Reserves, a member of the JAG Corps, and he understood the distinction between Title 18 in the domestic criminal courts and Title 10 law of war courts. You know, in your typical criminal case, let's say the Drug Enforcement Administration is going to raid a meth lab. You know, their end game, what they hope to accomplish in raiding that meth lab, is to prosecute the person that's operating it. So when they go to that house to raid it, they go with a search warrant. When they apprehend the individual, they read the Miranda rights to the individual. And all the evidence is cataloged and tagged, and you have a good chain of custody, so when you get to the courthouse, that primary objective can be carried out. That's the Title 18 process. Let's take the military commission process. And there's one case that I'll use an example because it's already begun and there is some record being developed. It's the Cotter case. Now, Mr. Cotter is the Canadian that has had a preliminary hearing. Now, what we've alleged in the charge sheet, and let me stress, these are the alleged, what's alleged, it's not proven. There's a presumption of innocent, and he's innocent until proven guilty beyond a reasonable doubt. But at least what's alleged is that he was involved in a firefight in which an American soldier was killed. Now, as you can imagine, in a firefight like that, the objective first is to survive. Second is to prevent the enemy from carrying out their objective. Third is to gather whatever intelligence you can gather. When is the next 9/11? Where are the bombs hidden? And prosecuting that individual is probably a fourth or fifth level consideration at the time they're apprehended. So Mr. Cotter was not read his Miranda rights. They didn't get a search warrant before they went into the house, and the evidence was not cataloged and chain of custody was not maintained. In a Title III court, we'd never get out of motions, as you can easily imagine. So the question then is, can we develop a fair system to deal with that type of fact? And I believe the answer is yes, we can. I can tell you when I first started out at military commissions, it seemed like we were blazing a new trail. And you hear some criticisms that they're making this up on the fly as they go. If you go back a number of years, it was comforting to go back and look at what Robert Jackson said 60 years ago. Robert Jackson was serving on the U.S. Supreme Court when he stepped down from the court to serve as the chief prosecutor at Nuremberg. And I went back and read his opening statement, which started at 10 in the morning and ended at 5 in the afternoon, which I can assure you, at my age, I'm not going to be talking that long. But what he had to say sounded a lot like what I would say to folks that question the military commission process. People are saying that this is new law that we're making up as we go along, and that these folks didn't know that what they were doing it would be handled in this manner. You know, I couldn't have said it any better than what Robert Jackson said 60 years when he had to confront a new enemy, the Nazis, that the law had not contemplated at that time. But the law can't remain stagnant, it's got to adapt. And that's what we're attempting to do with the military commissions. Again, like he said 60 years ago, I think the hope of the detainees at Guantanamo that we're bringing before military commissions is that the law will lag behind their conduct so that they can walk free because the law is not adapted to what they have done. And this is Robert Jackson at Nuremberg more than 60 years ago. And he got it right. This is not a domestic criminal trial, it's a continuation of the war effort. And I would certainly agree with his statement about extending rights and protections to the folks that are going on trial that they never contemplated. When Chandler Keller and Deng Chul Lee and Ruben Ornado were on that plane on September 11th, Al-Qaeda didn't ask, would it be convenient for you if we hijack this airplane? When Daniel Pearl was brought before a video camera and was executed in front of a video camera, his due process rights were not a great concern to Al-Qaeda. But despite the reprehensible nature of their conduct, we're equipped and we will provide a full, fair, and open trial for the folks that we're bringing before military commissions. And again, this goes back, as I mentioned, on the battlefield, when you're picking up information, you're detaining individuals, you don't have rights advisements, you don't have cleansing statements, you don't have chain of custody. But does that mean you can't use that evidence to produce a fair result? So I did find a lot of comfort, even though it seemed like we're blazing a new trail. It's a trail that hadn't been blazed before, when our country was at war with the Nazis in World War II, and Robert Jackson faced the same type of issues that we face today. You know, military commissions, if you look back, there are a number of articles that have been written on them. Military commissions have been used for several centuries in our country. Now, there's been a lull in the action. There hadn't been a military commission in several decades, but it's not unprecedented to proceed with military commissions. They stem from the President's authority under the Constitution as Commander-in-Chief, and they're expressly recognized in Title 10 of the United States Code. You know, it's funny because if you go back and look at what Robert Jackson said at Nuremberg, there actually is an excellent website if you ever have a chance to look at it. Robert Jackson, there's a foundation. You go to Google or Yahoo, put his name in, it'll give you the website. But he gave a number of talks later. There was one to the Canadian Bar Association in 1946 where he talked about the trials and tribulations of conducting Nuremberg and how people were critical of the process, that it couldn't possibly be fair. They were making it up as they went along. This was the headline from an article last week that talked about the legacy of Nuremberg and how the military commissions fall short of that standard. But to Robert Jackson 60 years ago, he was facing the exact same types of criticisms that we face today. All right, this is where we conduct the proceedings at Guantanamo Bay. It's the commission building. It's up on top of a hill overlooking the bay. You know, the whole authority for conducting military commissions, as I said, begin with the Constitution and Title 10. President Bush, on November 13th of 2001, entered a presidential military order that authorized the trial of enemy combatants before military commissions. His order applies to Al-Qaeda members and to those engaged in acts of international terrorism or those providing support to either one of those categories of folks. It requires a presidential determination that the individual facing trial meets that criteria. So each one of the 10 cases that are presently referred to trial, President Bush has made a personal determination that those individuals meet the criteria set out in his presidential military order. The order requires that we extend a full and fair trial to each individual. It provides the evidentiary standard, which is evidence is admissible if it would have probative value to a reasonable person. It provides for closed proceedings to protect classified information. And it authorizes the Secretary of Defense to issue orders and regulations to carry out the intent of the President's military order. Again, this is when we went down to Guantanamo in January. And one of the things I've tried to do in the time that I've been there is I think we have not done as good a job as we could of getting out and telling our side of the story. You know, the example that I'd given was when we got to the airport, if you looked out, the airplane only had left wings, you probably wouldn't get on it. You know, you need both wings to provide balance. So I'm pleased to have the opportunity to get out and talk whenever I can to try to provide some balance to the discussion. One of the things I've done is to try to be engaged with the media as often as possible. You know, one thing I've learned is, you know, the defense for a long time had a field day to say anything they wanted to say, no matter how outrageous, without any fear of the record being set straight. One thing I've learned in the last couple of months is there's some folks that just don't like hearing the truth. So I made it through 22 years with no ethical complaints. I've racked up 2 in 2 months now. So, you know, whether some people want to hear it or not, I'm going to continue trying to get out and tell the truth about what we're doing to hold folks accountable. Another thing I've tried to do is to engage with the non-governmental organizations that have an interest in what we're doing at Guantanamo Bay. This was from January of this year. From left to right, Avi is from Human Rights Watch, Catherine is from Human Rights First, Joanna is from Amnesty International, and Ben is from the American Civil Liberties Union. And both trips down there, I've sat down and spent time with them. You know, I didn't win them over at hello. I don't know that I ever will. But at least I think it's helpful we can sit down and have a conversation. And I've offered, you know, whenever they want back in D.C. to meet with them and to hear what they have to say. And it's not just them. I'm interested in what others have to say. You know, I kind of inherited a process. You know, I'm like the engineer on the train. I get to drive the train, but I didn't get to build the railroad. But I'm certainly interested in hearing other people's thoughts on how I can best do my job to ensure a full, fair, and open trial. This is a common picture you see of the detainees at Guantanamo Bay. This, I saw this picture again over the weekend. As you know, on Friday, the Department of Defense released several thousands of pages of information about the detainees. And in the news articles I read, this is one of the common pictures that's been shown to reflect Guantanamo Bay. What this picture shows you is from Camp X-Ray. Camp X-Ray closed, a little over 2 years ago. Nonetheless, that's still, every time you hear Guantanamo Bay, you see Camp X-Ray pictures. Here's a current picture of Camp X-Ray. There's another one. Nonetheless, in the media, to portray Guantanamo, you see that old picture of Camp X-Ray and the detainees that were kneeling out there in the yard. Well, this is what Camp X-Ray really looks like. These are what the current facilities look like. This is Camp Delta. They're in the process of building Camp 6, which I was down there last week. My understanding is that facility will be completed sometime this summer. And if you've ever seen any federal prison, that's what Camp 6 will look like. Camp Delta, this is what it looks like, not the pictures you see of Camp X-Ray. These pictures are available in the public domain. Yet, again, whenever you see something in the press, you tend to see the Camp X-Ray pictures. This is the inside of the facility. While we were down there last week, there was a delegation from the Office of Security and Cooperation in Europe. It was a Belgian delegation. They went out and toured the camp, and the headline over the weekend, I printed this off of the internet, the headline was, "Guantanamo better than Belgian prisons, according to OSCE expert." So you normally don't hear that kind of thing about Camp X-Ray, or about Guantanamo Bay. You hear all the negative. I can tell you that the young men and young women that are down there, when they meet each other, you know, the first one says honor bound, the other one responds to defend freedom. Now, there's some members of the bar that find that humorous that they do that, but they're a very dedicated group of young men and young women that are down there not under the best of conditions. They live in a place called Camp America that are plywood buildings with about 12 of them to a building sitting up on cinder blocks. It's not the best of conditions, but they're doing a very honorable job of representing our country. And that's not to say that some individuals have not done some things that we should all be embarrassed about. But a few bad apples shouldn't obscure our view of a very good orchard that we have down there. Again, this is the headline from ABC News. At the level of the detention facilities, it is a model prison where people are better treated than in Belgian prisons. But until recently, you haven't heard that kind of talk about Guantanamo Bay. In my opinion, I think it's a deliberate defense effort to avoid having to step into the courtroom. If they can drag this out long enough, if they can generate enough outcry through the media and in the public, then perhaps they can just make this go away. But the last thing they want to do is to have to step into the courtroom and actually face the facts, because they know that those facts are pretty compelling of the conduct that they engaged in, and that it's not unreasonable to hold them accountable for their conduct. Okay, this is the President's military order. Again, I'll show you the website in a minute. I'd encourage you, if you do have an interest in this, to go to our website and take a look. It's got all the authorities from the President's military order down through presiding officer memoranda that are available for your perusal. It's got the transcript of the proceedings that have been conducted to date and a whole host of information about what we're doing at Guantanamo Bay. The link for the website is listed there at the bottom. This just shows you the current cases that we're conducting and the information that's available. On there you'll find as I said, the President's military order authorized the Secretary of Defense to issue orders and regulations to carry out the President's military order. Secretary Rumsfeld has done that through a series of military commission orders, or MCOs. And there are currently 3 MCOs that are in effect. MCO number 1 is kind of the overarching framework for conducting military commissions. There was a recent revision to Military Commission Order number 1. It was published in August of 2005. There were a number of folks that said the way the original commission process was set up was unfair. You had the presiding officer, who was an attorney, in essence the judge, who was part of the commission. He sat with the commission members, he voted with the commission members, so in essence you had the judge sitting with the jury at trial. A number of folks said that's not fair. The judge, the presiding officer, ought to be more independent and like a judge than a voting member of the jury. I believe it was the American Bar Association was one of the leading proponents of separating the presiding officer out and giving them that independent judicial type role. In August, that was one of the major changes that Secretary Rumsfeld implemented in a new military commission order, where now the presiding officer rules on matters of law. The commission members determine the facts. But it's interesting, the defense complained initially that the judge was sitting with the jury and that wasn't really fair. So now we changed it to where the presiding officer is independent and not a voting member, and now the defense is saying that isn't fair because the President's military order says that the military commission will sit as triers in fact, and therefore you have to have the whole commission there to make any legal or factual determinations. We successfully won on a motion last week on that, because in the Detainee Treatment Act that was implemented on December 30th, it expressly references Military Commission Order number 1 that was enacted in August. So both the President and Congress have given their seal of approval. The Military Commission Order number 1 defines the commission personnel. The appointing authority is Mr. John Altenberg. Mr. Altenberg is a retired Army 2-star general who came back out of private practice to serve as the appointing authority. The presiding officers, there are currently 4. They're all 06s, as colonels or captains in the Navy that are experienced military judges. It defines the role of the chief prosecutor and the prosecutors that work in my office. Currently, I have about 15 attorneys working in the office from the Army, Navy, Air Force, and Marine Corps, as well as the Department of Justice. The Chief Defense Counsel is Colonel Dwight Sullivan. Colonel Sullivan is a member of the United States Marine Corps Reserves who was called to active duty, I believe, in July of 2005. Prior to that, he was serving as the director of the Baltimore office for the American Civil Liberties Union before being called to active duty in the Marine Corps. Colonel Sullivan, to be honest with you, I'm not sure the exact number of attorneys he has. I think he has 6 that are permanently assigned, 8 that are temporarily assigned. He's getting 4 more here in the next 30 to 60 days and 8 more before summer. So he'll have 24 attorneys assigned full-time to his office. Military Commission Order Number 1 provides for the presumption of innocence, proof beyond a reasonable doubt, defense access to evidence, the right to testify, the right to remain silent with no adverse inference, the right to present evidence and call witnesses and cross-examine witnesses. It establishes the post-trial appellate review process, and it also authorizes both the appointing authority and the General Counsel for the Department of Defense to issue additional regulations and guidance to implement the President's military order. Military Commission instructions are issued by the Department of Defense General Counsel. Currently, there are 9 Military Commission instructions. Probably the one, if you're only going to look at one, would be Military Commission Instruction Number 2, which defines offenses and elements of offenses. And the other Military Commission instructions primarily define roles and responsibilities and administrative procedures. Then the appointing authority is issued, currently has 3 appointing authority instructions that deal with disclosure of communications, trial procedure, and professional responsibility. Probably most importantly at the trial level for what we're doing are presiding officer memorandums. Colonel Brownback, Pete Brownback, was a retired Army colonel who had been a military judge for a number of years. He was recalled to active duty and was the first presiding officer and was recently appointed as the chief presiding officer. He's issued 15 presiding officer memorandums, which are really the details of how the commission process works. For instance, the President's order, the Secretary's orders didn't tell you how to style a motion, how to file a motion. So the presiding officer memorandums kind of flesh out the details of how the process works. As I said, currently we have 10 cases that have been referred to trial before military commissions. Everybody, I think, knows that the Hamdan case is one of the 10, is currently pending oral argument in the Supreme Court on March 28th, and we hope sometime in June to have a decision. From my perspective, I think there are 3 outcomes that are possible in the Hamdan case. The Supreme Court can say everything is fine as is, which is what the D.C. Circuit said. Chief Justice Roberts was on the D.C. Circuit at the time. But the D.C. Circuit said the military commission process is legitimate, the President acted within his authority, and we could press on. We're hopeful the Supreme Court will say the same thing. If you've been following that, you'll see Justice Roberts is sitting out. Since he was part of the D.C. Circuit when they rendered their decision, he's not participating at the Supreme Court. So it'll be up to the other 8 justices to reach a decision. But we're hopeful they'll say everything is okay. As you know, there are 3 issues that are pending there. One is whether the President acted within the scope of his authority when he created military commissions. Second is whether an individual has the authority to assert Geneva Convention protections. And a third issue that you won't find on their website was the effect of the Detainee Treatment Act. The Detainee Treatment Act says that the federal courts are divested of jurisdiction except in an appellate review process. So depending on how the court answers that third question of whether they still have jurisdiction, they may not have to get to the first 2. But certainly what we're hoping for is a decision from the Supreme Court that says that the commission process is legitimate and valid and we can press on. The second alternative is that they say the commission process is not fatally flawed, but some corrections are required. It'll be up to the administration then to decide whether to implement those corrections, but I would hope in fairly short order that can happen and we can begin with some trials. And I guess the third alternative is they say that the process is fatally flawed, in which case I'm unemployed and available. But we're hoping we'll get that decision by June, which I think at that point we'll have a pretty clear sense of direction. In the meantime, one of the questions I get is, well, why are you pressing ahead if you're waiting for the Supreme Court to render a decision. Last week when we were down at Guantanamo Bay, I know the representative from the American Bar Association was complaining about, these folks are languishing at Guantanamo Bay. It's been 4 years almost for some of them. They've never had their day in court, so why are you letting them just sit around and nothing happening? Then later he said, well, we shouldn't be doing anything while we're waiting for the Supreme Court to make a decision. Well, the Supreme Court granted cert in the Hamdan case back in October, I believe, October. So if we waited until June, that means we've sat for 8 months and done absolutely nothing waiting for the Supreme Court decision. So what we've tried to do is to continue moving forward with preliminary matters that don't get to the merits of the case, so that when we do get a decision, we're at a stage where we can make progress and not be starting from scratch. So, it's kind of, I quoted Bart Simpson when I was at Guantanamo when I said, damned if you do, damned if you don't, but that seems to apply quite frequently in military commissions. We're, damned because we're not doing anything, but when we do something, we're damned because we should be waiting and doing nothing at all. But I think we're doing the right thing by trying to move forward as best we can. I mentioned the Detainee Treatment Act. As I said, it purports to divest the federal courts of jurisdiction. Pretty much every detainee, somebody rushed in on their behalf and filed a petition, a habeas petition, in some court somewhere prior to the Detainee Treatment Act being implemented on December 30th. We're hopeful that the plain language will apply and that the courts are divested of jurisdiction except in their appellate role. Otherwise, the Detainee Treatment Act is pretty worthless if all 490 folks at Guantanamo still have habeas rights. It was kind of a waste of time to go through the whole process of implementing the Detainee Treatment Act. But it also creates a role for the federal courts. Under the old process, if a person was convicted in a military commission, when the process was over, there's a review board that would review the case for legal sufficiency and sentence appropriateness. The appointing authority would also review it, and then either the Secretary of Defense or the President would review it, and that was the end of the process. The Detainee Treatment Act provides for an appellate role for the federal courts. In addition to the process I just described, the D.C. Circuit would have jurisdiction to review the case, and then the Supreme Court would have an additional review beyond that. So at least 5 layers of review if someone is convicted before a military commission. So I guess kind of what I foresee as the road ahead is we're going to continue to prepare cases. We expect to, as I said, right now we have 10 cases where charges have been approved and referred to trial. I can tell you when I left the office yesterday, there's another case sitting on my desk that should be going to the appointing authority in the next couple of weeks for approval and referral to trial. The folks in my office have another, I don't know the exact number, roughly 24 cases that they're working at various stages. So I would anticipate between now and the Hamdan decision to forward several more cases to the appointing authority for referral. So when we do get the green light to proceed, we've got a number of cases in the queue and ready to go. I guess current issues, things that I think are of interest to you. One is you may have heard a little bit about torture. It's something, it's kind of the elephant in the room. If we don't talk about it, you can't really ignore it. I think the existing standards that we have in place are adequate to deal with the issue. The President's military order requires that the accused receive a full and fair trial, and only evidence that has probative value to a reasonable person should be admitted. So the presiding officer, first off, let me tell you, my perspective as the chief prosecutor, the 10 cases that have been referred to trial, the prosecution will not offer any evidence that, in my opinion, comes anywhere close to any definition of that anyone would call torture. That's not to say in future cases we won't have more difficult issues to face. But if we do, I've instructed the folks in my office that we are not going to press the edge of the envelope in trying to offer evidence that was unduly coerced. As I said, it's my objective to keep these proceedings as open as possible and also to ensure a full, fair trial for each individual. If the defense disagrees and they believe evidence was unduly coerced, they can certainly raise that before the presiding officer. The presiding officer will have to determine whether that evidence has probative value to a reasonable person, and if the accused will be denied a full and fair trial if that evidence is introduced. The one thing I've found is, looking at the different domestic and international laws dealing with torture, what it defines are effects and not acts. Generally it says, anything that creates significant physical or emotional pain constitutes torture. I think we can all agree on that standard. But when you apply that standard to acts, it's much more difficult. I mean, certainly there are some things we could all, 99 people out of 100 would agree that some things clearly meet that threshold. There are probably other things that 99 out of 100 would agree don't meet that threshold, but there's a tremendous gray area in between where personally each of us might strike the balance at a different point. So one of the issues that I have to face as the chief prosecutor is, on behalf of the United States, where do I strike that balance? I can tell you I haven't reached a firm and definite conclusion in my mind, so I'd certainly be happy to entertain any thoughts that anyone else has. But again, the presiding officer will have to make that initial determination. The members of the commission will have to decide what weight to attach to the evidence. And then there's that post-trial review process, including in the D.C. Circuit and the U.S. Supreme Court. So any issues of unduly coerced evidence will be fully vetted and fully resolved to ensure a full and fair trial. The other issue that I think is worthy of discussion are secret proceedings. I mean, that's thrown up a number of times. An individual can be convicted facing evidence they didn't even have a right to see. I can tell you in the 10 cases so far, I believe we can conduct many of those cases entirely in the open. The going-in position with my folks, I've instructed them that that's our primary objective, to keep the proceedings as open and transparent as possible. So if there's a piece of evidence that's classified and the only way to get it in is to close the proceedings, we're going to have to take a long, hard look at whether it is so important that we need to go to that extraordinary step of closing the trial. We'll make every effort to get evidence declassified, to keep it entirely open, but I can't rule out the possibility that in some cases there will be some closed proceedings. So I guess in closing, I would say that it was Al-Qaeda that declared war on America, and they chose terrorism as its weapon. It's my job as the chief prosecutor to prosecute unlawful conduct, not to persecute anyone because of their beliefs. In my opinion, it doesn't matter if you're Muslim or Methodist. It's your conduct that determines whether you're going to go before a military commission. I can tell you in the 5 months I've been there, I've been impressed by the caliber of the young folks that I've seen at Guantanamo Bay, and I'm certainly impressed by the ethics and integrity of the folks that work for me in my office. I can tell you from my perspective as your representative that you have nothing to be ashamed of what we're doing at Guantanamo Bay. So with that, I'll be happy to answer any questions that you have. Let me just say a word about the questions, okay? I just want to say a word about the questions. Oh, okay.
With regard to the questions, first of all, Colonel Davis is here to speak about the military commission's process. That's obviously his area of expertise, and so what I request is that the questions be focused in that area. Secondly, with respect to the format, everybody likes when they talk. Some people like to talk rather than ask the questions. For the sake of time, please ask and don't talk. Second of all, we anticipate that obviously many people will want to ask questions, so I really do request that you keep your questions brief. And lastly, you'll see a mic somewhere, or mics. Whoever wants to ask a question, please wait until the mic is in front of you, because this is being C-SPAN and there are people around the world who are going to be watching this. We want them to hear your questions. Colonel Davis, you've sat long enough. Come back. All right.
I have a brief two-part question.
All right.
What's the case against domestic trials? And second, when the military commissions have been conducted, how do we know whether the Jets have won?
I'm sorry, what was the first?
What's the case against domestic trials?
Against domestic trials? As I said, we would never get past the first motion. We don't have chain of custody. We don't have rights advisement. We don't have search warrants. Article III courts are not an option. And I think we've won. The Jets have won if we can provide a full, fair, and open trial. I'm not as concerned about the outcome as I am.
How will we know that?
They're going to be, I'm hoping the members of the press will be there to report it. I'd like to, as you saw in some of the pictures, the non-governmental organizations are there. I know I've talked with Professor Dior about the possibility of having some students come down. The biggest limiting factor right now is purely logistical. Just, you can't go to the Delta counter and get a ticket to Guantanamo Bay, so just getting there is a bit of a challenge. There's a limited amount of space for people to live in the courtroom. It's your typical military courtroom where they felt compelled to put a post right in the middle of the courtroom so nobody has a clear view, but there's a limited amount of space. But, as I said, I really want to make these as open and transparent as possible. So if we could have some students come down, that would be great. Certainly the press will be there to cover it. And I'm just hopeful that we can show the world that we're going to do this right and do it fairly. Whoever has the mic.
Colonel Davis, correct me if I'm wrong, but I believe you mentioned earlier that there really isn't a chain of evidence in these commissions. And one of the things that I'm curious about, I don't mean to sound cynical, and I'm certainly not implying anything by this, but given the sort of chaotic and very emotionally charged nature of a battlefield scenario, what sorts of protections can the commission, or even you personally as a chief prosecutor, offer to assure that there's no manufacturing or tampering of evidence in the process?
I can't speak to every piece of evidence, but I can tell you, if it's your face on the video, then it's probably you. And for some reason, Al-Qaeda, they love video cameras and tape recorders, and a lot of that stuff was left behind. And it's not to say there is no chain of custody, but it's not, in your typical police case, they're going to start from the first second up until that moment in the courtroom. You can see everywhere that piece of evidence has been. In our case, it's not to say there's entirely no chain of custody, but it might have been a day or two before things calmed down enough to fill out an evidence tag. So, and again, I can't tell you every piece of evidence, but certainly it'll go to the weight that the members attach to that piece of evidence. Whoever's got the microphone has the floor. Yes, sir.
Military commissions were used most notably during the Civil War and the Vallandigham case and others which arose out of Ohio here, but also during World War II against Nazi saboteurs. Most historians think that the Civil War commissions overstepped their bounds, that they used far too loose a standard, and they were really swept up in the passions of the time. The World War II commissions generally are regarded as being handled a bit more even-handedly.
Right.
Given the groundwork that was laid by the War Department in those days, have you found that useful at all? Have you learned from the mistakes that were made? And how are you doing things differently that future historians will say they got it right?
Yeah, I think we certainly learned some lessons, but I guess, as I said, I kind of inherited the railroad. The process had already been created. I got there 5 months here. The process had been kind of laid in place before I ever got there, so I hate to say I was stuck with what I got, because I think it's a good process. I think the things I found more instructive, or like I said, on the issue of coerced evidence, where do I strike the balance? And those are more subtle questions that, certainly what happened in the past is relevant, but I'd certainly be interested in current thought on where to strike the right balance on that. Yes, ma'am.
You stated that you were not planning on introducing evidence obtained through coercion. I'm wondering two things: whether it is the position of the prosecution that such evidence could be introduced, and with regard to what you would be willing to introduce, what would you consider to be coercion that would make it unacceptable? Would holding a man in pitch darkness surrounded by loud music render his confession inadmissible, or would hanging him by his ankles and beating him?
Yeah, it's really a tough, as I said, all the standards talk about the effects, severe physical or mental, emotional pain or discomfort. Then trying to apply, like the examples you gave, trying to apply specific acts to produce those results is a more difficult question. I don't know. The way the rules are written, it's up to the presiding officer to determine whether the evidence has probative value to a reasonable person and whether introducing that evidence would ensure a full and fair trial. So there is no blanket prohibition. Regardless of where it falls on the spectrum, there is no blanket prohibition. But there has to be some point at which any rational human being says, we're not going there.
Could you give me an example of what such a point would be?
Boy, I really hate to do so because there's so many. I can tell you the example. If you look at the transcript from the Al-Balul case when we were at Guantanamo last week, the example that the presiding officer used during voir dire of him was, if you poke somebody in the eye with a hot needle, that's torture. I agree. Now, there's probably several grades short of that, but exactly where is hard to say.
Hello. Thank you. First of all, thank you, sir, for your service.
Thank you.
Has 9/11 ever been connected with Afghanistan in terms of, was it plotted there? Is there evidence that it was plotted there?
Trying to think of how much I can. Boy, there's certainly evidence of the connection to Afghanistan, but beyond that, at this point, I probably can't answer that. So I think the answer, if you stand by, I think you'll.
Were most of these people at Guantanamo Bay captured in Afghanistan?
Yeah, I think Major Shavers, correct me if I'm wrong, I think the vast majority were, but not all. They're in the Afghan theater.
So what would they be prosecuted for?
Right now, what I can tell you, I think the number is roughly 490 folks that are detained at Guantanamo at present. Right now, 10 have been charged. I don't know what the final tally is going to be. All 490, I can pretty much, I hate to say guarantee you, but I can probably guarantee you that we're not going to prosecute 490 people at Guantanamo Bay. So the number is going to be more than 10. It's going to be less than 490. I don't know what the final number is going to be. As you probably have seen, I probably should have talked about this. At the time someone is apprehended, there's an initial determination made there at the, fairly shortly after they're captured, that they either are or are not a combatant. If they're not a combatant, then hopefully they were released. If they were, then we continue their detention. When they get to Guantanamo Bay, there's a combatant status review tribunal, which is a 3-person panel that looks at the facts and makes a decision whether the person is or is not a combatant. Then that's a one-time process. After that, there's an annual administrative review board, which then looks at, is the continued detention of this person necessary to protect the United States? I think the number, there's been, 186 people that have been released as a part, 187. Yeah. 267 have been transferred, 187 have been outright released through that review process. Now, I've heard different numbers, and I can't tell you exactly, but I've heard 12, I've heard 15, I've heard 20 of the people, that 187 that have been released that have either been killed or captured, in combat action since then. If there's 12, 15, or 20 that were killed or captured, there's obviously some number that's still out there engaging in combatant activities that haven't been killed or captured. So I guess the point would be, as careful as we are in this review process, there's still a good percentage of these folks that we determine are no longer a threat that wind up going back and jumping back into the fray.
Colonel, what's the range of sentencing that these people face?
It would be from no punishment to the death penalty, depending on the case. Mr. Altenberg is the appointing authority, and it would be his decision on whether a case is referred as capital. So far, the 10 cases that have been referred to trial, none of those have been capital referrals.
You say that there's 5 layers of review for each case after a decision is made.
Correct.
Now, suppose your military commission heard a case, and you know after the review of the facts this guy just isn't a terrorist. You don't have the goods on this guy. It's like, then can the Department of Defense or the President of the United States overturn your decision after you have examined the evidence and where the President or the Department of Defense doesn't know anything about the case?
Yeah, one of the steps in that review process is the Secretary of Defense or the President. The way the rule reads, the President has to review, post-trial reviews the findings in the sentence. He can delegate that authority to the Secretary of Defense. So one of the two will review every case that where there's a conviction and a sentence imposed in a military commission. After it goes through the President and the Secretary of Defense, then it goes into the D.C. Circuit and then to the Supreme Court. So they're kind of, the middle of that five-step process.
Where does the buck stop, basically?
Well, I guess the Supreme Court would be the last avenue, but at least in my opinion, I haven't really thought this through, but I would assume at that point the President as Commander-in-Chief would still have the authority to take whatever action he deems appropriate.
Colonel, you have said that the law of war needs to develop in light of new circumstances. What are some of those changes that you think should be made?
There are a whole, one of the issues that, on this that really has nothing to do with military commissions, but the law is slow to evolve. One of those areas is contractors on the battlefield. We've got a lot of folks that are doing things that in the past someone in a uniform did. And what is their status, like under the Geneva Conventions? If someone is operating a Predator, that is a contractor, what is their status? Or the folks that are providing logistical support in Iraq or Afghanistan. It's an area where I don't think the law is caught up with the realities of today's environment. The same applies in dealing with an enemy like Al-Qaeda. The Geneva Conventions contemplated, nations going to war, people in uniforms with, carrying arms openly. It didn't contemplate, folks strapping bombs to themselves and walking into crowded rooms and detonating them. So
are you suggesting that the Geneva Conventions be changed?
They could use some freshening up.
I guess I'm asking this question given the current administration not having a substantial record of, say, admitting to mistakes or acknowledging criticisms. I'm wondering, should this military commission proceed, and if it after the some cases have gone through, if it continues to draw criticisms by NGOs or by the press, whether you take responsibility and determine that military commissions would not be appropriate or fair or full or open, and whether you're even in a position to do that given the hierarchical nature of the organization that you work for.
You're doing so good right up to the end there. I don't think, I've been in the Air Force 22 years, so I'm retirement eligible. So, I have no ambitions to be a general or the Judge Advocate General of the Air Force. I'm looking to do a couple more years and retire. So I'm not, as far as being independent, I think I'm about as independent as I could possibly be. I probably couldn't walk next week. I think I incurred an obligation when I actually moved a few months ago, but I'm pretty close to being able to walk away. If it ever got to a point that I wasn't comfortable, that's exactly what I would do. I don't think that would be based upon non-governmental organizations or the media not being happy with the process, but if I felt like the process is not producing a fair result, then I can find something else to do with my time. That answer your question, or?
Well, we'll be watching your response then.
All right. Yes, sir.
Hi. Just wondering what some of the circumstances or national security concerns would be as far as some of the detainees providing testimony that would need to go into some sort of closed session or something. I've been trying to use my imagination. I'm not really sure what those circumstances or what kind of information they might have that would be a threat to national security.
Yeah, I'm trying to think. I don't know that a detainee necessarily testifying would trigger that, but the way some of the evidence was collected, the sources, and for example, you saw where shortly after the war, the ground war really started. It became fairly common knowledge that we were able to track the cell phone calls, which is a pretty effective. You make a cell phone call, and 30 seconds later, a bomb falls on you. It didn't take too long to figure out that we could figure out where you were off your cell phone, so that source of information dried up. So what we're trying to protect with the closed proceedings would be sources and methods of collecting information.
Colonel, this question's from the overflow room. Would you please discuss Mohammed Al-Qatani, detainee number 63? Particularly, there was a story in this week's Time magazine article which contains a log that allegedly reports abuse. So I guess the question here is just whatever you can discuss with regards to detainee 063 or allegations of abuse.
Okay. Yeah, I think in the public domain there was the article that came. Al-Qatani is referred to as the 20th hijacker. That he showed up in Orlando a couple of weeks before 9/11, and he was not granted entry into the United States. And Muhammad Atta was there at the airport to pick him up. So, I guess one could draw a conclusion that he might have been that 20th person. I've also seen the allegations that he was subjected to undue coercion or torture, or however you want to frame it. That's not a case that I mentioned there are 10 that have been referred to trial, and a couple of more that are sitting on my desk. Al-Qatani is not one of those cases, but certainly those are the kind of facts we're going to take a hard look at. And again, I'll tell you, my position is if there was evidence that was obtained through undue coercion, then I'm instructing my office not to go forward with that evidence. Now, if we can prove the case, with other evidence, then I don't think the fact that somebody did something they shouldn't have done gives you a free pass to engage in terrorism. But we're not going to go forward with evidence that would deprive someone of a full and fair trial.
If you find someone that is innocent, I think that's what this person was saying, and can the President or the Secretary of Defense overrule your decision or the levels of decisions saying that person is not an enemy combatant?
So you're saying that if I go forward with the case, could they?
If you don't.
Oh, okay, and then I'm getting pressured to go forward anyway.
Yeah, can you be pressured to go forward? Can they overrule your decision?
Well, I could. Go back to the answer I gave to that other question. That'd be the time I'd head for the House and call it a day.
Colonel, you mentioned that a number of detainees have been released or transferred and so forth. Where are you sending them? Are they being transferred to other, detention facilities? Are they going through other proceedings? What's going on with those detainees?
They're going back to their home country. I think, again, the number, I think 267 have been released, 180 were outright just, you're free to go. The others were released back, it was through the State Department working with their government on conditions to release them back to the custody of that government.
We have another question from the overflow room upstairs. What is going to happen to detainees whose status can't be determined after a certain point in time, such as if there's ambiguous evidence?
Again, you have the Administrative Review Board that meets annually, and that's a process to determine whether the person, is a continuing threat to the United States. And as we said, there's been 260-some people that have been released because they're no longer viewed as a threat. As also said, that hadn't proven entirely accurate because we've had quite a few of those folks that have gone back and taken up arms again. But I can't tell you a point in time, that each person will be released, but they're reviewed annually and that decision's made. That's a responsibility that falls under the Secretary of the Navy, I believe, is in charge of the Administrative Review Board process. And at least from what I've seen, the Secretary has been pretty independent in making the decisions that the Secretary determines are appropriate.
I have two questions. First of all, isn't there a danger that the process will become inherently unfair just by the
amount of time that it's taking to bring these cases. 4 years, 10 cases, about 2.5 cases a year. We have 490 detainees. I don't know what, that's about 200 years that it'll take to adjudicate them. And my second question is, what is the end game here? Once somebody has served, presumably we're not going to execute all these people. At some point in time, they're going to serve their sentences. And if they're still determined to be enemy combatants at the end of their sentences, what do we do with them? Do we get like the Israelis do? They sign a pledge not to engage in future activities, and or do we stick them on some border somewhere?
Yeah, and I can tell you, as much as anyone, I am not pleased at the glacial pace at which we've been proceeding. I can tell you, it's not due to any lack of effort on our part. We would like to have seen these things move at a much faster clip, but well, it's not a matter of people. We've had the defense at every opportunity has used the federal court system and any reason to delay the proceedings as much as possible. And again, my view is I think it's a deliberate strategy to drag this out to try to generate that outcry of public opinion and just make this whole thing go away. I could be wrong. But 4 years is too long. We need to, hopefully when we get the Hamdan decision, we'll get the green light and we can press ahead in an expeditious manner. You did the math right. I mean, if we prosecuted every person at the pace we're going, they'll die of old age long before we ever get to trial. As I said, though, we'll not prosecute all 490 people. The number will be something greater than 10 and something less than 490, but I can't tell you exactly what that number is going to be. There's a good article coming out. Brigadier General Tom Hemingway is the legal advisor to the appointing authority. He has an article coming out in the Denver Journal of International Law where he does a very good job of differentiating between the authority to detain a combatant and keep them out of action, out of combat, and the authority to prosecute war crimes. And I'd encourage you, I'm not sure the exact date that's coming out, but sometime in the near future. I've seen a draft of it, and it's a very good article that explains the difference between serving a sentence and being detained and removed from combat.
Follow through on this subject of delay. You were very helpful, and I appreciate the explanation on the prosecutorial process.
Yes, sir.
You did gloss over, and then you went back to the idea about the commission of people who evaluate who is and who isn't and so forth. I'd like you to give us some more detail on that, because that's where the delay is. Is your staff involved in that, or are there people who are lawyers or trained people, or are these political appointees, or who are these people that determine in the first instance whether somebody should be held and prosecuted?
All right. Whether they should be held, the combatant status review tribunals, there are 3 officers that sit on that panel. I don't know that if there's an attorney. I don't think there. I think it's 3 officers that sit on that panel. And again, it's kind of outside my lane. I'm not involved in that process. I know there are 3 officers sit on the panel. They review the evidence. The accused does not get the right to counsel, but does have a representative to assist in presenting information that the detainee wants the panel to consider. That's a one-time determination. Then annually they have the Administrative Review Board that determines whether there's still a continuing threat to the United States. Now, neither of those processes apply if their case has been referred to trial before a military commission. Because if we're going to prosecute them for a war crime, then obviously the President has made that reason to believe determination, and there's no need to conduct the annual review.
So before it ever gets to your department, there can be somebody languishing in jail as a farmer or a salesman that got hooked up, and he can lay for a year before anyone listens to him.
Theoretically, that's possible, but I haven't seen that case so far.
You mentioned earlier that while you are able to retire at any time, there are other younger people working in office. And in regards to other points made earlier about political pressure into this judicial process, what safeguards are there against political pressure from above to younger members of your team who cannot retire?
Right. Well, it's the same as in in the court-martial process. We have unlawful command influence when you have superiors that try to manipulate the process to achieve a certain result. I don't know. I mean, I don't know that there is a guarantee.
My question's a procedural one, and it relates to what I will call wrongful classification. When certain evidence has been determined by the classifying authority to be classified,
Right.
The question is, does the commission have any right to question that or to be able to request other review, or do you just automatically have to go into a closed session to be able to present that evidence? So that's
We do have a review. You know, the initial request to declassify a document goes to the owner of that information. If we disagree, then we have an appeal. Well, not an appeal. There's another. We can elevate it to a higher level within the Department of Defense for a fairly high level second opinion. But that would be the end of the. That would be a final decision at that point. But certainly, I don't think we have the authority then to have the commission second guess the classification process. That's just not their role.
And procedurally, how quick does that happen, and how independent is that other group?
I don't know, because we really, at this point we have not gotten to the merits on any case, so we haven't had that issue come up, so I can't tell you definitively how that's going to work. Yes, ma'am.
Hi, Colonel.
Hello.
I just want to clarify. I do understand the Geneva Convention does not apply.
Mm-hmm.
So do we use the term prisoner of war for these people, or is enemy combatant the term of art here?
Yeah, we don't use prisoner of war in the sense of Geneva Convention. We don't use that. Unlawful enemy combatant is the designation that we typically use. Right.
Can that apply to a U.S. citizen or strictly a citizen anywhere else in the world?
Under the President's military order, it doesn't apply to U.S. citizens. It expressly says it's only applicable to non-U.S. citizens.
So any U.S. citizen who does a terrorist act would be tried through our judicial system. Anyone who's a citizen outside of the United States who performs or appears to perform a terrorist act would then go through this military process.
Right.
You said that there's 400 some people currently at Guantanamo.
Roughly 490.
Okay. I don't know my name. And I'm sure there's a reason why they're there. My question is, obviously you cannot prosecute them all.
Right.
Those that you determine are a danger to our country.
Mm-hmm.
We are currently in a state of war, a war that I cannot conceive an end of because we don't have a government to basically give in or do a treaty with. So it's conceivable if we never try them, they're determined every year to be a danger. If they could pretty much sit there the rest of their lives?
That's a possibility. But I don't know any war that we've ever gotten into that we knew what the end point was.
Well, true, but haven't we always been at war with countries until now? I mean, we were at war with Japan, we were at war with Germany, we were at war with places.
Right.
Now we're at war
with Al-Qaeda.
Yeah. They don't have a country, they don't have a president, they don't have anything that says, hey, we can settle with these people.
Right. Yeah, I mean that's an executive branch decision. Is when is the war over? But your hypothesis that this could go on in perpetuity is a possibility. Come on, one more hour.
Before we say thank you to Colonel Davis, a couple of closing comments. When we planned this, to be very frank, I don't think we expected it to be this incredibly successful. And the reason it has been so incredibly successful because of one man, and that would be Colonel Davis. Having been in a position not dissimilar from his during the course of my own career, I frankly know how difficult the job is, how awesome the responsibilities are, and I turn to you, Mo, as a friend. I say we really all are very grateful and thankful that you are in that position. As a small token of our appreciation, it's like Christmas now. First, the formal gift. I think on behalf of all of us, we really do give this to you, and truly thank you.
Well, thank you very much.
And then there's some goodies. There's a nice sweatshirt and so on. There's a reception upstairs. Finally, thank you.
Thank you.
Take up the mic.
Hey, and please at the reception, don't hesitate to come up and let's
Let's
talk.
first leave before you all jump on him.